Inadmissibility of family member on grounds of inadmissibility of the principal applicant. A foreign national who is a member of an inadmissible person's family and who is accompanying the inadmissible person to Canada. There's an exemption. Section A42(2)(b) stipulates that a foreign national referred to in subsection 1 who is a temporary resident or who has made an application for temporary resident status or an application to remain in Canada as temporary resident is inadmissible only if they are an accompanying family member of a person who is inadmissible under Section 834, 835, and 837. For example, a dependent son who is accompanying his inadmissible father who made an application for a permanent resident visa, the son is inadmissible on the ground of an inadmissible family member of his father is inadmissible on any of the grounds enumerated at A34 to A41. For example, another one, a dependent son who is accompanying his inadmissible father are seeking temporary resident status. The son is only inadmissible on the grounds of an inadmissible family member if his father is inadmissible. If the inadmissibility of the principal applicant comes under the minister's jurisdiction, the officer must prepare two separate reports. I'm saying about the IRCC or immigration officer, one regarding the principal applicant's inadmissibility and the other regarding the family member of family inadmissibility. If the minister then decides to make a removal order against the principal applicant and his son, the minister must do so by making two separate removal order. If on the other hand, the principal applicant's inadmissibility comes under the jurisdiction of the Immigration Division, the A44 report regarding the foreign national is sufficient and a separate report does not have to be prepared for family members. R227(1) provides that the report prepared regarding the foreign national also applies to accompanying family members. According to R2272, the removal order made by the Immigration Division against the principal applicant also covers family members if the conditions in R2272 and B are met. Namely, this one, an officer informed the family members subject to A44 report that they are the subject of an inadmissibility hearing and of the right to make submission and the right to be presented by counsel at the admissibility hearing at their own expense. And the family member are subject to a decision of the Immigration Division that they are inadmissible under Section 42 of the Act on grounds of inadmissibility of the foreign national. At the inadmissibility hearing, the fact that the condition in R227 was met will be proven by producing the notice of admissibility hearing of family member form. To meet the conditions in R2272B, it is sufficient to show that the family member meet the definition of family member in R13. If these two conditions are met, family members will automatically be covered by the removal order made against the principal applicant. R13 provides that foreign nationals' family members are the spouse or common law partner of the person, a dependent child of the person or of the person's spouse or common law partner, and a dependent child of a dependent child referred to in paragraph B. The term common law partner and dependent child are defined in R1, 1, and R2 respectively. Example, a father and his dependent 18 years old son apply for admissions as permanent residents. The father is inadmissible on grounds of serious criminality, A36-1B. The officer prepares a single A44-1 report regarding the father, which also served as a report with respect to the son. The officer issues a notice of admissibility hearing to family members. That's gonna be the form to the son. The MD refers to the report of an admissibility hearing. At the end of the hearing, the Immigration Division decides that the father is inadmissible under 836-1B and makes a deportation order against the father. The deportation order will also automatically include the son if he was issued a BSF 540 form and the son is family member within the meaning of the regulations. So that is what they call the inadmissibility situation if the principal applicant is the one that's about to be deported.